Hi, my name is Adam Whitmer. I'm the founder and host here at ComplianceCohort.com. This compliance clip is going to talk about disparate impact. Now, disparate impact is one of three types of discrimination as defined by the court system. Now, this is actually a three-part series that we're doing as a compliance clip, which is a free video we're offering to you here at ComplianceCohort.com. And this is one of those three videos. Now, the three types of discrimination are each of our videos. So the first type of discrimination is overt evidence of disparate treatment. The second type is comparative evidence of disparate treatment. And the third type is evidence of disparate impact. So that will be our topic today. Now, this is actually a topic we just talked about in our Fair Lending Bootcamp that we have released in our store. That is an on-demand program that takes a very deep dive into fair lending. In fact, it's a full-day virtual seminar. So if you've not seen that, you can take a look at that in our store, compliancecohort.com/store. Now, as far as disparate impact, this is interesting because I saw an example of disparate impact just this week in a question that came by that I'll share with you in just a minute. Now, what disparate impact is it's something that occurs when a lender applies a racially or otherwise neutral policy or practice equally to all applicants, which doesn't sound like a problem, but the result is that the policy or practice disproportionately excludes or burdens certain applicants on a prohibited basis. So it's an unintentional consequence to a policy that appears in and of itself to be neutral, but has the ultimate effect of discriminating based on a protected class. I'll give you two examples. The first example is the question I saw this week. The question said, is this an underwriting problem? What they were doing was they were requiring proof of income for retired applicants in every situation. But for employed applicants, if their credit score was over 720, those applicants did not have to prove their income. So what they had was, again, employed applicants, if your credit score was under 720, you had to prove income. But if your credit score was over 720, you did not have to prove income. For retired applicants, in every case, they had to prove income regardless of their credit score. So the way that could be disparate impact is you have retired individuals who would potentially be elderly customers as defined by Regulation B. That is what age? That's age 62. So if you have elderly individuals who are required to prove income, compare that to somebody who is not retired and who is employed and they do not have to prove income. You're making that elderly individual jump through more hoops than you would a similarly situated younger individual. So you can see how that could be potential disparate impact, and that's a potential type of discrimination. Now, another example of this would be potentially a loan amount. This is another example of potential disparate impact, is if you have a rule that says we're only going to lend to applicants who have a loan amount of $450,000 or more. Now, I completely understand why some banks might do that, because it's much more profitable to do one $450,000 mortgage than it is to do 10 $45,000 mortgages. But what ultimately happens is if you require a mortgage to be at least $450,000, you're potentially discriminating against certain protected classes. What protected classes would those be? Well, those would be those like maybe women applicants or younger applicants or retired applicants or minorities or anybody who doesn't make that type of income in order to qualify for a larger mortgage. So those are examples of disparate impact. And in our Fair Lending Bootcamp, we actually give another third example. But this often occurs in minimum loan amounts, like I explained, but you could have a minimum loan amount. You could have a business necessity. You could say, look, we're not going to do loans for mortgage loans for $1,000 because they're not profitable. And you're allowed to do that as long as you prove it as a business necessity. So what you really want to do in your organization is to figure out what that line is as far as your profitability and justify it, document it so you have it available if you ever were to receive a complaint. But I will tell you, there was a bank that was requiring a minimum loan amount of $450,000. They got hammered by the regulators, and they had to decrease that down to a minimum loan amount of around $30,000, which they were able to justify as a business necessity, saying that amounts lower than that would not be profitable for them. So as long as you justify it, that could be okay for you. So that is disparate impact, one of the 3 types of discrimination. Now, this again is a compliance clip. If you're new to the compliance cohort, our compliance clips are free to our free basic members. We have a basic membership that's absolutely free. You can sign up on our site, receive training videos just like this. We have articles and other resources available to you, as well as a weekly Friday email update. If you're an existing member, we thank you so much for sticking to the end. And again, if you're interested in learning more about fair lending, take a look at our Fair Lending Bootcamp and our store at compliancecohort.com/store. Thanks so much for watching, and I hope you have a wonderful day.